party to which you have contributed. Now I come, my lord, 2013 to complete the scheme of the Companies Act, my lord.
We now look at the 2017.
17, my lord, on the right-hand column.
Which,
my lord, first it deletes the requirement of 7.5%. Proviso is deleted.
yes.
Subsection 3 is substituted, my lord. Subsection 3 is substituted.
Yes.
And the substituted section says, omits the requirement of giving particulars of the amount and the name of the party to which has been contributed.
Yes, we got it.
Subsection 3 is inserted to 182. May I read that? 3A is inserted. Answers, yes. Notwithstanding anything contained in subsection 1, the contribution under this section shall not be made except by way of account pay check drawn on a bank or an account pay bank draft for use of electronic system through a bank account. So very loud, you cannot make cash payment basically. Provided that a company may make contribution through an instrument issued pursuant to any scheme notified under any law for the time being in force for contribution to political parties. So subsection 3 substituted deletes the requirement of giving the particulars of the political party. I'm so sorry.
Even if it's deleted, there is no other requirement. There is no mandate that it should not be disclosed.
Yes, my lord. There was a mandate you must disclose. Now that mandate is gone.
That's fine.
My lord.
See, the accounts under the Companies Act,
yes, my lord,
are maintained for the purpose of ascertaining the real income.
My lord.
These are different from the income tax account.
Yes.
Normally, under the Companies Act, the tendency is to overstate the profits, because then you get more credibility in the market.
Yes, more funding.
Have more access to credit.
Yes.
Whereas it's opposite in the Income Tax Act.
Yes, my lord.
There is a tendency
tendencies to reduce so that you pay less tax.
You save tax. But in this case, even if it is deleted, you have to disclose the amount which has to be paid. 2, there is a requirement for the Board of Directors resolution to be passed.
My lord.
The Boards of Directors resolution will contain the name of the political party or may not contain the name of the political. But there is no express bar to not disclose.
No. There is no bar, my lord, but there is no requirement, my lord. If the law has been changed, my lord, a requirement is deleted. Presumption would be it's not required to be disclosed. The interpretation would be, my lord, otherwise, the substitution of section 3 is meaningless, my lord. Substitution of section 3 is, my lord, with a new subsection, that you delete the requirement
what is new subsection 3?
Subsection 3 is, my lord, substituted with on the right hand side.
Page 8.
Page 8, my lord, all of your lordship.
Every company shall disclose in its profit and loss account.
Yes, total
amount contributed by it under this section during the financial year.
That's all, my lord. Yes. Disclose. I've contributed X amount.
The words any.
Yes.
Is
any amount or amount.
It just says, instead of any, it says total amount contributed by it under this section.
Please, Lord.
Earlier provision was any amount or amounts contributed by it to any political party during the financial year.
My lord.
The reference to the political party is taken away first in 182.3.
Yes.
And it just says any amount contributed under this section.
Yes.
Secondly, that what is deleted is giving particulars of the total amount contributed and the name of the party.
Name of the party.
Yes. Has been
so they just say I contributed for political parties X amount.
By inference, it can be implied inference, it can be drawn that the name need not
be disclosed.
Yes, not required. That's the whole purpose of this, my lord. And when your lordship
Name
sees
of the party need to be disclosed. No, name of the amount to be
this,
disclosed.
The
yes,
total amount.
Not
X
the
amount,
part. Yes.
X amount is to be paid for political,
flexible,
X amount is paid for political contributions. That's all, my lord.
You
Because
don't, you
180
merely
to
say
1.
that, you merely say that I've contributed 100 crores for political contribution.
That's all.
But you don't have to either give a bifurcation or name the party to whom you are.
Yes, my lord. Yes.
So it becomes now an anonymous.
Completely, my lord. And because you get tax exemption, 80 GGB, you get the complete tax exemption of whatever you have contributed to political contribution.
Otherwise, it won't be covered by 37.
Yes.
Until somebody claims it's
100%, my lord, to a charitable trust, we get 50%, my lord, under 80G. And there's a cap, my lord, I can contribute only 10% of my income to the, for a 50%.
charitable purpose.
There's a cap for a charitable purpose. To political parties, I can contribute any amount and get 100% deduction.
All right, we got that.
Yes, my lord. And proviso lordship has seen, my lord.
Yes.
So now, my lord, lordship may come back to my submission, my lord. This is what the Companies Act amendment has done.
So now we are in volume 4.
Volume 1A
Sorry,
again, my
you are
lord.
in
I'm so
volume
sorry.
one.
Volume 1A is my
Yes,
submission.
Yes, of course.
Page 20 and 21 are my submissions on what has happened to these changes.
19 now.
Yes, my lord. Your lordship has
We have
seen, my lord.
seen 20.
Yes, 16, 17 and 18. Lordship has noted it from the volume 4. The changes made.
Would you like to read para 19, Mr.
May I read para 19, my lord?
I think that's
Yes,
your submission.
that's my submission, lord.
Yes.
Thus, the companies all along, since 1960 till 2017, have been mandatorily required to disclose not only the amount contributed, but also the name of the party to which contribution is made. Further, there has always been restrictions such as the ceiling that the contribution shall not exceed the prescribed limit 5% under the Companies Act, 7.5% under the Companies Act 2013 of the average profit of the past 3 years. By virtue of the said condition, it was ensured that the shell companies were not able to make contribution to political parties. The above conditions have thus helped to ensure transparency in political funding. The fact that such provisions, said provisions of Section 293, capital A, equivalent to Section 182 of the COP, help to achieve the objective of the transparency has been acknowledged by this Honorable Court in the case of common cause. Lord, I've given the paragraphs. I'll give it to your Lordship, the paragraphs of this judgment. It is pertinent to note that when Finance Bill 2017 was initially presented, there was no proposal to dispense with the aforesaid conditions. However, the Finance Act 2017 amended Section 182 and conditions to disclose the name of the party and the ceiling of the amount permissible contribution was dispensed with. After the commencement of the Finance Act 2017, now, Lord, what is the position now? A company is now only required to disclose in its profit and loss account the total amount contributed by it, without being required to disclose the name of the party to which the amount is being contributed. Thus, the company may only require to declare that X amount has been donated without any details, which makes it impossible to trace as to which party is being funded. Even the shareholders may not know. Funded to which the corporate entity, making the corporate funding vulnerable to gross misuse and abuse. There is no ceiling on the contribution made. Thus, the contribution may be made divorces probability. Shell companies as well as loss-making companies can make contribution to a political party.
That's fine.
One level,
My lord,
all this has been regulated by statute,
my lord,
right? Right from 1956.
my lord,
The nature of the regulation has been by statute.
my lord.
The only point is this: absent an enabling provision in the statute, namely the Companies Act, no company can donate for political purposes at all,
Yes,
right?
yes,
So though at a certain level or at first blush, this is regulated by statute.
My
What
lord.
is conferred by statute can be taken away by statute. All right. No implication of a fundamental right can arise. So for instance, just wait a minute.
my lord, my lord.
It may not be against you.
Yes, yes, no, I'm
Uh,
not.
Suppose there was no provision in the 1956 Act
My
at
lord.
all for political contribution. What would be the consequence? Consequence is not that companies are free to donate for political purposes untrammeled by any other provision. The 1956 Act, for the first time, when that enabling provision came, provided, in fact, initially there was a complete ban. 1960 was 5% of the net profits or
Yes.
20,000 rupees.
My lord.
Absent that provision, you could not have contributed at all.
My lord.
Then comes the ban in 1969.
69.
Ban is lifted in 1985.
85.
So though it is a matter of statutory regulation,
Yes.
absent an enabling provision, a company cannot contribute to
My lord.
political purposes.
My lord.
So if the constraints subject to which those contributions are permissible are lifted by the legislature,
My lord.
they are amenable to be tested under Article 14.
Article 14. Yes, my lord. And it is manifestly arbitrary, my lord. There are two reasons which are given.
So it's not just a question of what the legislature enacts, it can take away. There's no fundamental
it is
right.
not like that, my lord.
But
Yes.
when you are making an
This-
enabling provision
My lord.
for contributions
My lord.
and taking away the restraints on companies,
Yes.
the taking away of those restraints is amenable to be tested.
Is unable to be tested on manifest arbitrariness, my lord. Because, my lord, there are two objects which are given. To give transparency, I'll show to your lordship that only two objects which are given, my lord, for amending
That we have
this.
seen
No,
now.
my lord.
I mean,
Lord, it has-
transparency
Lord,
and other things you
very
will
well,
not
Lord.
repeat because that your predecessors all argued.
Very well. So it is amenable to be
But this was
tested.
very valuable because you have given us the complete
My
legislative
lord, I'm
history.
grateful to your lord.
Now, what do we from here?
Now, would your lordship see similar changes in the Income Tax Act?
All right, let's see the income tax.
Yes, my lord. Which are in, my lord, page 12 of my same compilation.
Well,
My lord. May I read, my lord? This is 70 page. No. इसीलिए कोट किया हुआ कोट किया हुआ ओके
yes.
वो हेडिंग डी पेज 12
D, yes.
evolution of income tax benefits in the context of political parties. I'm so sorry. May I, my lord?
Yes.
Evolution of income tax, page 12 of volume 1A. Benefit in the context of political party amendment to not to keep the records and yet granting tax benefit in contradiction to the initial object behind introducing such benefits. Now, section 13A was introduced in the Income Tax Act 1969 in 1978, whereby the income of a political party inter alia from contribution received was exempted. The exemption was provided to address the issue that such taxation of their income reduces their disposable funds, adversely affecting their capacity to finance their activities from the legitimate source of income. Then, my lord, I have quoted the objects and regions. Lord, you may just skip over and see the top of it, page 13. Now, that was regarding the Companies Act. Now, this is regarding, my lord, the political parties. Heading of page 13, exemption will not be allowed unless the political parties maintains proper books of account, records the name and addresses of every person who has made voluntary contribution of
This is a
more than
statement of
12,000.
objections. You're reading the statement of
I'm reading below statement of reasons, then
Yeah.
I'll come to the section below. I just an accounts political audited by the chartered account, and then section 13A inserted by 1978. Special provisions regarding to income of political parties. Any income of political party which is chargeable under the head interest of securities or interest from other sources, or any income by way of voluntary contribution received by a political party from any person shall not be included in the total income of the previous year of that political party, provided. Now, my lord, it's exempted provided. These provisos are important. Such political party keeps and maintains such books of account and other documents as would enable the income tax officer to properly deduce its income therefrom. Now, Lordship has seen yesterday, Mr. My London friend Paratha said, one DV, KV has given 1 lakh, and that is exempted, my lord, without details. My lord, my submission would be, my lord, when it comes to the scrutiny of the political party's income, my lord, nobody applies its mind. The income tax officer should have said, my lord, you are required to disclose details, accept cash of 1 KV, my lord, of 1 lakh rupees. Page 5553, my learned friend Mr. Farah had showed that, my lord, to your lordships. And that is accepted. Whereas the requirement of Income Tax Act that you must books of accounts so that the income tax officer properly distributed income from. Second, in respect of such transaction in excess of 10,000 rupees, such political party keeps and maintains a record of the contribution and the name and addresses of the person who made the contribution.
What is the next thereafter? What is the
Yes,
change?
my lord.
Made?
And my lord, this then political, then this, my lord, has been changed in 2003.
Where is that?
Next page, my lord, page 14. And my lord, I have quoted the statement of objection regions that may not be lordship, may not, or I can read that, my lord, because 2003 as the large number of changes in the Income Tax Act, my lord, and the Electoral Bond Trust, my lord, I'll invite your lordship's attention as it came, my lord. It was introduced to keep the identity of the donor, my lord, which is being said corporate houses to be secret, my lord, not to go in public domain, etc. The purpose of one of the things is said that has been taken care of by Electoral Trust. In 2003 amendment, my lord, the objection reasons, Law Minister's statement is quoted. Lordship may skip over that. I have given the reason, my lord, as the bold portion. May I read, my lord, at page 15, the bold portion, middle of it. Just get me the Income Tax Act. You have the Income Tax Act? Income Tax Act.
Let's read this para 10, which gives sums up what happened.
Yes, my lord. Para 10.
So till 2003, there was no equivalent of 80 GGB and 80 GGC.
Please, your lordships.
So at that time, therefore, these donations will not be covered by Section 37 of the Income Tax Act.
Yes, my lord. No, Section 13A.
37 is the expenditure clause.
Lord,
They will not be covered. It's not wholly.
The donor will not get, my lord, the exemption.
Donor will not get the exemption.
Yes, the political party is receiving, my lord.
They are exempt.
Their income is exempted provided those conditions are met.
Satisfied.
But the donor will not get it.
It was not treated as expenditure in the hands of the donor.
Please, lordship. And 80 GGB and 80 GGC. Would your lordship see this section, lord? It's not available on record, my lord. I have given the books.
Who uploads are 80 GGB or 80
Yes,
GGB?
I have given in the
Meet to political.
Who? Isme hai? No, we have given the list. Anyway, it doesn't matter. My lord, may I just read the summary of it, my lord, and in the meantime. Yes, it is. Yes, it's there. I have. Yes, my lord, may I read para 10? Made the following major amendment. 80 GGB and 80 GGC was inserted to provide that. I'm so sorry. My lord. Objection.
Then.
Section 80 GGB and GGC were inserted in the Income Tax Act to provide that the contribution made to the political party shall be deductible. That is, whatever is the amount contributed, a deduction is admissible to the expenditure of or that amount so contributed would be available to the donor under the Income Tax Act. This was intended to incentivize persons to give donations to the political parties by check, and these donations were also disclosed under the Companies Act. Lots of you have seen. My lord, may I just pause here and if Section 80 GGB. It's here.
Yeah,
Okay.
got it, yes.
Yeah. May I read that, my lord? It is there in your lordship screen. So you would get it the footnote inserted by Act 46 of 2003. Deductions in respect of contributions given by companies to political parties in computing the total income of an SSE, being an Indian company, there shall be deducted any sum contributed by it in the previous year to any political party. Look, let's stop here. That is it in 2003. The next part has come in 2017 or 2009. That is the Electoral Trust. I'll come to that little later. And 80 GGC, that is companies, GGB is company, and GGC is individual, deduction in respect of contributions given by any person to political parties in computing the total income of an SSC being a person except local authority so and so to any political party.
All right, so we got this 80 GGB.
Yes, my lord. So, my lord, in 2003, exemptions are given to the donors also, my lord.
Right.
So we can donate any amount of money, exemption, my lord. Now comes, my lord, 2009.
Yeah.
That the scheme of electoral trust is introduced, my lord, by inserting section 13B. 13B. In which year? Section 13B, my lord, 2009. Any voluntary contribution received by an electoral trust shall not be included in the total income of the previous year of sub-trust if such electoral trust distributes to any political party registered under section 29 capital A of the Representation of People's Act during the previous year 95% of its aggregate donation received by it during the previous year along with the surplus, etc. May I just explain the scheme, my lord? So 5 companies can create an electoral trust. You make the company makes a contribution to the electoral trust. It reflects that I have made a contribution to the electoral trust. Those pages are here, my lord, unfortunately in here, to a electoral trust. The company's account will show that only. And my lord, and the electoral trust must make 95% of its contribution to the political parties. It gets, my lord, deductions completely. So through that route, my lord, companies can make donation to the political parties.
Yes.
And 80 GGB and 80 GGC is also amended in 2009 to show, my lord, that any donor to the electoral trust also gets an exemption.
Yes.
And Lord, may only make a note, my lord. Rule 17CA of the income tax rules, my lord, makes the detailed provisions about how to electoral trust is to be function, my lord, maintain, etc. account details. So the scheme is, my lord, in 2009. You make an electoral trust. Company make donation to the electoral trust, you get an exemption.
5 companies could set up an electoral trust.
That's exactly has happened, Manoj.
And was there any restraint on how the electoral trust should contribute to a political party, or they could contribute to any
Electoral
political
trust,
party?
but it has to mandatorily contribute 95%.
But was there a requirement of disclosure, maintaining accounts, etc.?
That is there in the rules, Manoj, in 17CA.
Rule?
Rule 17CA of the income tax rules changed in 2013. The complete thing is made in
No,
2000.
this provision was incorporated in 2000, was enacted in 2009.
Yes.
So the rules must have been made at that time itself.
Or they came at the first time?
I'm sorry, Manoj, I couldn't get.
The rules must have come in at that time itself. Was there any restriction as to the quantum of donation which should be given to a particular political party? Was it restricted on the basis of the electoral
No,
share?
basically idea was, Manoj, the corporate identity
share?
may not be disclosed.
No, that's fine.
So this is the route.
For the outgo, was there any restriction as to whom it should be across the board, or it was restricted only, it was complete? You had the option to go to give it to any political party.
Electoral trust, Manoj, has to be, Manoj, the formulation has to be approved by the income tax commissioner, etc. Rules have said.
No, but the point is,
Yes,
would
no.
an electoral trust say that we are going to give money only to one political party?
Yes.
Or was there, let us see that rule. You
Yes,
said
no.
rule 17CA,
It can
Rule
be given to
17A.
one party also.
one party also.
That I have the,
No, there was no restriction.
there was no restriction. Instead of 5 people differently donating,
They
they
all
create
give
a
it to an
trust.
electoral trust.
There are some 28 trusts and that scheme still continues.
Right.
But
Yes.
it was found to be a non-starter.
It was, we'll
I'll
come
show
to
the
that,
figures.
but there was no restriction that you had to equally distribute
No.
or proportionately distribute.
No.
Between
But like-minded people can come together, create a trust and donate to one party.
17CA.
I don't know, I got some impression that probably there was some proportion.
Look, I can.
That's-
No, we have the figures on record. I'll show to your lordship.
No.
Electoral trust figures are on record.
Collectively, they may have given to different parties, but there was no rule,
No
prohibition or embargo
All right.
that they have to equally distribute.
No.
They can give to one party.
Let's see that rule 17ACA,
Sib-
because 13B, subclause B says, such electoral trust functions in accordance with the rules made by
My
the
lord,
central government.
that's the rule 17CA.
Now let's see what that rule says.
Yes, my lord.
Rule 17CA upload kar dijiye zara.
No, I think. Rules are not there, my lord. They're not online. You have it online? Can you share it? We have it online. Link. Is it?
Yeah, give the link to him, he'll do it. Share.
Can share it?
Sanjay?
Can we share our screen?
But I
हाँ.
don't-
आप आपको लैपटॉप दे सकते?
I can adopt that.
Can we mail to your lordship that ID, my lord? Huh? Mail.
Mail it to the court master, no problem.
Yes, mail it to court. Only 39, 17CA.
ये बंद कर दो जरा, सेकंड माइक बंद कर.
हो गया? Okay.
Would you send or I can?
Your
The
control.
functions of an electoral trust.
Your morning.
Side of.
Oh, that, it said the electoral trust shall not accept any money from, I just missed it here, from any foreign entity, whether incorporated or not.
Yes. So foreign entities come now, my lord. I'll show to your lordship, presuming the FCRA regulation is valid. Even in defense sector, my lord, they can pump any amount of money, defense companies. Yes, yes, it has come on. If a lordship see, my lord, 1 to 6, who said, who electoral trust can accept money from whom?
थोड़ा scroll कर लीजिए नीचे.
7 is possibly answering your lordship's questions.
7 दिखना, हाँ, थोड़ा सा ऊपर जाइए बस. नहीं, ऊपर और. Political party. रुक जाइए.
Only to eligible political parties.
And
29
7. A
Spend up
politic-
to 5% of its total contribution.
No, because 95% you have to contribute. 5% only you can keep. 7 is important and 8 is important. First, lordship may permit me to read 7.
Just read 7.
Yes, my lord. A political party registered under section 29 capital A of the RP Act shall be an eligible political party, and electoral trust shall distribute funds only to the eligible political parties. So, my lord, you can distribute, my lord, to whichever political party, but registered under 29A. I'll come to the scheme of RP Act. 8. Electoral trust may, for the purpose of managing its affairs, spend up to 5% of the distributions received in a year, subject to an aggregate limit of 500,000. You can add up and solve it also. Okay. In the first year of incorporation, rupees 300,000 is subsequent years. I'm sorry. और भी कोई है इसमें relevant?
Fact that in the Election Commission of India, then issued a directive. They issued a directive after this rule was brought into force,
My lord.
mandating a disclosure by political parties of contributions which were made.
My lord.
Once the Election Commission of India mandated an exercise of its powers under Article 324
Yes.
that there should be a disclosure,
Yes.
then this became a non-starter because then you had to come up into the public realm
Yes.
on what you have donated.
No, but lord, they have distributed the figures. I will show to you, lord.
Right, we'll see
The figures are there on record. Page. That distribution amount.
Yeah.
May I read, my lord, two more sub rules of this, my lord? This is very important. Sub rule 9. The trust shall obtain a receipt from the eligible political party indicating the name of the political party, its permanent account number, registration number, amount of the fund received from the trust, date of the receipt and the name of the designate of the person signing such receipt. Electoral trust shall not utilize any contribution for direct or indirect benefit of the members or contributors for any purpose, namely executive, etc., etc. Corporate entity cannot use it, give it here and then use it for their own purpose.
Then the electoral trust shall also maintain a list of persons from whom contributions have been received.
Yes.
And to whom the same have been distributed, containing the name, address, and permanent account number of each such person, along with the details of the amount and mode of its payment, including
Yes.
the name and
Yes.
branch of the bank.
Yes. Electoral Trust has also maintained a list of persons from whom contributions have been received. I'm so sorry. From whom contributions have been received and to whom the same has been distributed, containing the name, address, or permanent account number of the person, as well as details of the amount and mode of payment, including the name of the branch of the bank. 12. Every electoral trust shall get its account audited by an accountant as defined in explanation to section so and so, along with so and so. An electoral trust shall maintain a regular record of proceedings of all meetings and decisions. 14. Electoral trust shall furnish a certified copy of the list of contributors and a list of political parties to whom such sums were distributed in the manner prescribed in Subrule 8 to the Commissioner of Income Tax or the Director of Income Tax, as the case may be every year. So, my lord, the income tax is there, election commission, my lord, by virtue of that, it is there.
I don't think, subject to correction, I think the rules were introduced only in 2013.
My lord,
So till 2013,
Yes.
the 2009 amendment was.
electoral
never-
trust route was not available.
So it was never got enforced.
And now, after being
Conformity
available,
with the rules, because it had to function in accordance with the rules.
in accordance with the rules. So,
So
still
long
the
the
rules
rules
are
were
framed.
not formulated, there was
Yes.
no guidance in the
Yes, my lord.
functioning.
And if your lordship now see, my lord, how many electoral trusts has been formed, etc., that is in volume 4, page 7311.
Volume 4,
7311 is an analysis of electoral trust contributions by ADR for the year 2015-16. Yes, 7311, volume 4.
There were total 18, but
Yeah.
8 didn't receive anything at
If your
all.
lordship see below page 7134, the contributions, there are 18 electoral trusts who have contributed 49 crores, roughly. So solicitor saying it didn't work, my lord, that the route which, because it was transparent enough. Corporates cannot, my lord.
Basically, there's only one trust which had substantial.
Yes, my lord, that's only one trust, my lord.
Satya.
Satya Electoral Trust. So total is 49 crores, my lord, only 47 crores is by one trust. To whom, my lord, 5 corporates houses may have donated money or contributed money. This is for 2015-16.
They must have tap pass.
18-19 it improves, my lord, which is figures are at page 7326.
But that gap under the company.
Seven three two six, my lord, in the same volume, volume 4, is the analysis for 2018-19. And at 7335, give the figures, my lord. There are 25 trusts. And my lord, the total figure is at page 7335, 252 crores. There also, my lord, now some other prudent electoral trust contributes the major part of it.
25 trusts, is it?
Yes, my lord. And these are available, my lord, with Election Commission. My lord, Election Commission has a very important role. Now, my lord, with this scheme, Election Commission has been completely shut out of all information. That's why your lordships have passed that interim order. I do not know, my lord, whether the Election Commission has brought those details to your lordships, my lord. But they said in the subsequent order, we have it, we have kept it in seal cover. And lordship would see, my lord, in the yellow, not available on ECI website, even 5 electoral trust or 6 electoral trust does not give it, my lord.
All right, then.
So, my lord, now the final amendment is lordship would get it, my lord. 2009, your lordship has seen the amendment. Now 2017 amendment, my lord, which your lordship would get in Mr. Bhushan's note, my lord, volume 1. At page 8, bottom. (13A) is amended by 2017 Finance Act. And the amendment is on the right-hand side at page 9 of volume 1. I know. This is the existing provision, my lord, till 2017. Lordship has seen 13A. Now, on the right-hand side are the changes made in bold. So, earlier requirement was, my lord, you have to disclose every contribution in excess of 10,000 rupees. Now, it says on the right-hand side, clause B of proviso, because they can get exemption or deduction, my lord, only if they fulfill these conditions ABC till 2017. And 2017, this 7 ABCD. CB has been changed in respect of voluntary contribution other than by way of electoral bond. Now it comes, my lord, that if you make changes or contribution other than electoral bond, you will be eligible for exemption. So you don't have to give the details of the electoral bonds. That is one change made, my lord, in clause B. Second change is, my lord, clause D is added. No donation exceeding 2,000 rupees is received by such political party, otherwise by an account pay check drawn by a bank or an account pay draft or use of electronic clearing through a bank statement or electoral bond. So, Lord, you cannot pay cash in excess of 2,000 rupees now. Earlier, you could have received cash, my lord, but you have to give the details above 10,000 rupees.
Yes.
Now, my lord, D is important that you can receive, but otherwise then electoral. And what is electoral bond is explanation, my lord. For the purpose of this proposal, electoral bond means a bond referred to an explanation to subsection 3 of section 31 of the RBI Act.
Yes.
Now, lordship would immediately come to page 10. What are the changes? Because it says, as defined in the RBI Act. Now, what is the change in the RBI Act? Lordship would get at page 10 of the same volume, volume 1.
Yes.
Now, my lord, section 31 is the, my lord, of RBI Act 1934. Issues a complete ban on issue of demand hundi, my lord, promissory note. And this, in fact, my lord, gives in your hand an electoral bond. I can valid for 15 days. I have a currency to print myself, my lord, electoral bond. I take it. I'll show to you, lordship, how it works.
Yes.
Yes. I will show to you.
I can print.
I will have it in my hand as I want. As is cash, as it cash, I don't print it, the scheduled bank prints it, my lord, I know that.
Telgi, if you.
Yes, yes.
Yeah.
Notwithstanding, Lord, what is added is subsection 3 in the RBI Act. Notwithstanding contained in this section, the central government may authorize any scheduled bank to issue an electoral bond. Explanation: for the purpose of this subsection, electoral bond means a bond issued by a scheduled bank under a scheme notified by the central government. So, Lord, and that bond scheme, Lord, Mr. Bhushan has shown to your Lordship, Lord, how it works. State Bank of India can do it valid for 15 days. What I'm showing to your Lordship, Lord, the details of these donations by electoral bond is done away with by section 13A amendment, clause 4. Proviso, clause D added to proviso of 13A.
Right.
So, my lord, no longer disclosure of the
So now we
receipt
see-
amount by electoral bond.
Yes.
Now, fourth change made is in the Representation of People's Act, 1951. Which is there at page 7. Excuse me for a minute. Lordship may only make 2 notes, my lord. Representation of People's Act, section 29, capital A, is inserted, my lord, in 1989. Till then, my lord, there was no provision for political parties so far as, my lord, statutory recognition. 29A, which is in volume 4, page 27, it is there, my lord. That 1980, chronologically, let me go to it, my lord. 1989, section 29, capital A is inserted.
Volume 4 page.
Volume 4, page 27.
All right. This provides for recognized political parties.
Yes, my lord. Statutory recognition of political parties by the RP Act, which your lordship will get. Volume 4, page 11 is.
Volume 4 page.
Lordship, this starts at 27. Lordship, at 46, my lord. Yes. 1989, this section is added. Page 46.
Yes.
Registration with Election Commission of association or bodies as political party.
We
in
need to read the
association
whole
of-
thing. We just
That's
saw
all right. No, general. I'll just giving the history, my lord. Then 2003, along with those changes in the Income Tax Act, my lord, section 29B and 29C are added at page 47. 2003 is a lot important for the making the donations to the political parties, which 29B permitted political parties to accept contribution from companies, but no contribution from foreign source. And my lord, what is important is 29C, that they have to give reports of contributions in excess of 20,000 rupees. And details would mean, my lord, the details of the persons of identity, not KV. Lord, which your lordship will get in, where the corresponding changes have been bold. Contain 4 enactments, my lord, lordships are concerned. Now, my lord, before lordship
of the right to
Yes.
suffrage.
through its representative, political parties are the organizations represented here and there. First, my lord, lordship is CP and GGC. The election expenditure, the political parties, my lord, which incur are not added to the candidates. So that's again, my lord, important thing which benefit received by the political parties. All these are to show that political parties perform a very important function in the democratic setup. Fourth, my lord, D, Under the 10 schedule, as your lordship has said, my lord, they are bound to vote as per the whip of the party, irrespective of their conscience of the, otherwise they are in disqualification.
Which one?
So, sir.
Now what next?
Yes, my lord. My lord, I have given, my lord, case laws at para 44, how the importance of political parties has been recognized by this court, my lord.
Yes.
I'm not reading them. And 45, 46, my lord, the Law Commission, Justice Venkatacharya Commission also recognized the importance of political parties. But one question which your lordship fell, my lord, what is the manifest arbitrariness? It fell from your lordship Chief Justice yesterday, my lord, and my colleagues. My lord, my submission would be, my lord, that 2 or 3 things. One is, my lord, the distinction made between a normal bank transfer with the disclosed, I can make donation of any amount by bank transfer. Both are by bank transfers, my lord. Lordship has seen electoral bond is also, my lord, purchased from A through the bank, anonymity, but it is by bank transfer. So you are making a distinction, artificial distinction between a honest contributor who is making disclosure to all of all its funding to the political party, to the shareholders, and to the public at large. Because I have missed out one provision, my lord, I'll show to you, lordship. Conduct of election rules, form 24A. Everything beyond 20,000 is to be disclosed as per the rules. So an artificial distinction is being made between a bank transfer by an honest corporator who wants to say that, yes, I have made this contribution, and to another, my lord, who wants an anonymity. And there is no intelligible difference between these 2 transfers. Both are bank transfers. Earlier one is with transparency, and second one with opaqueness. Secondly, my lord, as I said, lord, this, how does it work, this electoral bond? For example, my lord, a KYC compliant company purchases electoral bond worth 100 crores. It doesn't want to give. Another person wants to give money to a ex-political party, my lord. It doesn't want to show. It has cash component, my lord. What is going on, my lord? I have talked to certain, my lord, chartered accountants. There is a premium attached to it, my lord. I can buy 100 crores by giving 125 crores, my lord, of cash.
You just said that.
That's what your lordship said. And lordship would find out from any chartered accountant doing this, my lord, and that is a very accepted, that 20 to 25% premium is charged by giving cash. So person who is purchasing the electoral bond is getting 100 crores, is getting 100% exemption. Another person who wants to pay to another political company, he paid cash and it reaches the political party, my lord. This is how, my lord, this electoral bond is now functioning, the thousands of crores.
So if, say, a contribution has to be made of 500 crores to a political party,
My lord,
technically you can find 500 people who will each make a contribution of 1 crore,
yes,
who will each purchase an electoral bond of 1 crore,
yes, my lord.
right? Each of those persons gets an exemption of 1 crore,
My lord.
a deduction of that 1 crore
Yes.
because you've
He
contributed.
gets the deduction of 1 crore.
For
He gets
purchasing.
cash for that.
The political party, it's exempt,
Yes,
but the person who is aggregating
yes,
and actually contributing 500 crores,
yes.
all that they have to do is to trade on the electoral bond, pay cash.
That's right. So he's ultimately paying cash, my lord. And that's why I said this is almost a cash available with hundreds of crores rupees available to a person, my lord, who wants to pay cash. This is the manifest arbitrariness in the entire scheme, my lord.
So the actual contributory
Yes.
is not necessarily the person who is
No,
purchasing
not
the electoral
necessarily.
bond through official banking channels at all.
So I want to pay and avoid ED, my lord. I want to pay a government which is opposite to central government. Let me put it that way, my lord. To a government in state. I don't want to show to the government, my lord, I have paid. So because the government would know, my lord, to whom it has been paid. Mr. Bhushan has shown to your lordship through, my lord, the State Bank of India route. I don't want to say, my lord, who has paid. I want to keep an anonymity. I paid in through, purchase it and then pay it. Because those bonds, my lord, bonds are there on record, my lord, it does not show, my lord, the number. Infrared number is available, my lord. If your lordship see the format of the bond. Just show that. What is that?
That's
Lord,
fine because
lordship has not been shown the bond.
The bearer bond.
it's a bearer bond.
Yes.
It's a bearer bond.
Sorry. the bond?
Or we like those Kisan Patras and no?
I'm so sorry.
Kisan Vikas.
Kisan Vikas Patras.
Kishan Vikas.
My choice.
It's not this much.
Page number. We have noted. Or you would give me a minute. I'll show the bond.
The Kisan Vikas Patra has numbers. This has no number.
No, it's an
That's the
infrared
distinction.
number. I cannot see with the naked eye. Only Milord, the infrared person can see.
Some identification.
Yes, there is. I'm going to, my lord, point out that, my lord, we learned it.
It's a cache. Lots of us see.
Let us see it.
Volume 4, 514.
How did you acquire so many electoral bonds?
It's a currency.
Can I have one?
Can-
I have not seen this.
Yes. We have seen it from the record.
Can we have?
Just
One more
give more. Distribute it so long as it is not of 1 crore, I hope.
Doesn't have a value and date of issue.
It is there in volume 4, page 4514 also, Milord. But this gives a better look. If you Lord, Google it, Milord, it says on the infrared, you can see a number here, not by naked eye. It's a number. But then,
Admitted by the ministry.
yes.
It has to be numbered, otherwise how will they, will be fake bonds?
By an official document which is part of the file.
But Milord, you and I.
So there is
did
a
it
number which can be seen on the infrared.
on the infrared by, Milord, the authorized persons, Milord.
Right, it is easily available.
515.
It's the same can be seen on light, my lord. It's not that child's play. There is a system I am going to
No, we cannot
explain.
see.
No, but
This is only a picture. This is only
even
a color.
actual you can't see like
color photocopy.
in the.
Before that number in infrared, you can't find. But this is the specimen.
Specimen is 514. Also, may page the note also.
We can see
Very well. No, this is there. This is much better. Amount we आपने छोड़ रखा.
All right, anything else, Mr.?
Yes, Milord. No, that's-
I think we better wrap up now.
I just two more minutes. Milord, internationally, this is, Milord, a very difficult subject, Milord, which has been, there is a study, Milord, I'll just give the page numbers of that on record, by Council of Europe, which has 45 member countries, 46 member countries, Milord, which is in volume 4, page 6920, which has raised serious concern about enormity of the funding by the corporate houses, Milord. If your Lordship kindly see that, Milord. Just 3 or 4 pages of that, Lordship may make a note of it.
That's all right.
It starts in volume 4, page 6920.
We look at it, Mr.
Yes, and just give the page numbers of relevant page numbers, Milord.
6920.
6920 it starts, Lordship may note 6928, 6930,
6928.
28, 6930, 6934, 6939, and 6941. It has raised a serious concern, my lord, about, and the heading is financing political parties.
Thank you very much.
Extremely grateful to your lordship,
Ansari.
and I must acknowledge, my lord, the indebtedness to my colleagues, my lord, who Mr. Kalita.
You've unfolded it very systematically. We really appreciate it.
And
Thank you very
two
much.
interns who have done it, my lord, a great help. They are also here from college students. They have given again chart, my lord. I've made them sleepless nights, my lord. Nikita and Sanjiv, my lord. I'm extremely grateful to my lordship. Oh, Lord, only one thing here. 20 section 29C, lordship has seen, my lord.
Yes.
Required. There is a form 24 capital A, in which you have to give form 24 capital A of the conduct of election rules, in which you have to give the details of the contribution of 20,000 and above. There is a statutory form given, and from where, my lord, we get all these details, and they're uploaded on the website of the Election Commission.
These are uploaded on the website?
Yes, my lord. And we have, my lord, all those uploaded documents from where we made the chart at pages 59 to 63. Lordship, I kindly only note 2 pages of my note, my lord. I'm not reading it. My written submissions, my lord, volume 1A,
Pages?
pages 69 to 63, 59 to 63, where, my lord, the calculations have been made as to the percentage of undisclosed source of funding, which varies from 63%, 65%, 72%, etc., etc. Year-wise given, my lord, and these are all from the website of the Election Commission. And this
Yes.
is where the charts have been made by my colleagues, my lord, spending sleepless nights and my employees. I'm extremely grateful to your lordship, my lord.
Yes, Mr. Hegde. Thank you, Mr. Ansariya.
Keep this bond sitting. Please, my lords.
What is your line of submissions, Mr. Hegde? What is the line of submission?
My lords, most of my submissions have been covered. I most respectfully adopt them, endorse them, and vehemently adopt them. Now, my lords, what I propose to do is to buttress some of the submissions. I won't take very long. Please, my lords. My lords, I appear in IA number 106839 of 2018. The applicant is a shareholder in a public listed company. Like the original petitioner in the Jayantilal Kotecha case, who had 3 shares in Tisco, I have a few shares in a few companies. My lords, he has been a public interest litigant earlier also, my lords. My lords, your lordships was shown the electoral bond. And as your lordships was shown that electoral bond, the figure that came into my mind was of the late lamented Mr. Ram Jethmalani, who really brought political corruption to the fore when he demonstrated to a press conference in 1993 how 1 crore was fitted into a suitcase. When I spoke to my younger colleagues, they said, oh, yes, 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 we saw it in a Netflix series. Scan, sit down. Today, whether it is a sum of 1 crore, whether it is a sum of 100 crores, all that it requires is just that one piece of paper that your lordships has been presented.
Suitcases are not required. Suitcases are not required.
Suitcase not required. One brief envelope suffices. And that brief envelope is time limited.
15 days.
15 days. My lords, there was a better copy at page 6919 of an actual electoral bond for 1,000 rupees, where even the stamp is issued.
6919
Of volume 4. 19 of volume 4. Your lordships will see that there is a date of 23rd of January 2023. And the words, for value received, the bank, which is the State Bank of India, hereby proposes to pay on demand to the eligible payee which is holding this instrument upon surrender of the original instrument in the designated account of the eligible political party with the bank, the sum representing the value of this instrument in accordance with the scheme. On payment of the said amount, the liability of the bank hereunder shall stand fully extinguished. So what has been created is a time-denominated anonymous currency. This is, my lords, the currency of power. And I make this submission simply because long ago it was a British Chancellor of the Exchequer, Lord Thurlow, who said, corporations have neither bodies to be punished nor souls to be condemned. They therefore do as they like. A corporation is a juristic person consisting of various shareholders. And those shareholders who are in management take a decision on behalf of other shareholders or on behalf of the juristic person that they will contribute. They will buy electoral bonds, and then they are given a further assurance that their contribution to X political party or Y political party need not be reported to anyone.
Yes.
So, if my lords then see in actual practice over the past few years what has happened, your lordships have been shown various records derived from political party statements, which have been further analyzed by the ADR. Now, my lords, my client, what he has done is, he has gone to the balance sheets of certain listed public companies. They are not before your lordship, so I am not going to mention any names. Your lordships may treat them as Corporation A, Corporation B, Corporation C. But now, please, if your lordships just turns down towards now page 6916, two or three pages before that, my lords. Now, 6915 is the corporation's statement of profit and loss. Thankfully, my lords, those documents are also highlighted at the relevant portion. Now, here, they do not even put in the profit and loss statement, as they are required to under the law, that they have actually bought election bonds. What is done is the next page. Other expenses. And in other expenses, right at the bottom with a double hash, it includes rent, printing, stationery, security repairs and maintenance expenses, etc. Further, it includes political contributions amounting to 273 and 412 made under 182 of the Companies Act during the year of March 31st, 2020 and 2019. Now, this is not 412 rupees. This is expressed in crores. And how do you know that? You go back, because you have to go not crores, my lords, in. Please get up. Please stop.
All amounts.
all amounts
Millions
are
of
in
Indian
millions of Indian rupee except per share data. Right at the top of page
So
6915.
it is 412 million rupees.
Yes, is 41 crores. So similarly, my lords, and since your lordships, one of your lordships has
If
penchant for figures. Yes, my lords.
6914, it's specifically miscellaneous expenses
691.
include donation of rupees 20 crores paid to political parties
Yes, my lord.
through electoral bonds.
वो अलग हैं, वो budget
हाँ,
finance
that
है.
is that is another corporation, my lords. Each of the corporations
Okay.
there are no fixed standards. Each corporation puts it somewhere or the other. Some include it with rent, stationery, and the rest. My lord, sometimes it's said that the truth in affidavits, what is revealed is interesting, but what is concealed is vital.
That's how the accounting treatment takes place in the corporation.
Please, my lords. So now what is it which is actually required, my lords?
What
And,
is the
if
Mr.
you
Hegde
look-
now, what's the submission?
My lords, the submission is this, that even under the current law, at page 8 of the same volume, Mr. Prashant Bhushan's chart, what is required is that no such contribution shall be made by a company unless a resolution authorizing the making of such contribution is passed at a meeting of the directors, and such resolution shall, subject to the other provisions, be deemed to be justification in law. Each time that there is a purchase of an electoral bond by a company, there has to be a resolution of the board of directors, which is not normally open to the public. They are not, the company maintains minutes books. It is available for inspection. Each of these resolutions, my lords, because these electoral bonds are election specific.
Not
It
necessarily.
can't be.
No. It's the bonds are sold at certain specific stipulated times in a year. January, April,
No.
October, and then 30 days for the general election.
My lords, it is whenever there is an election in a.
The argument of Mr. Sibal is that it's not election related at all. Because when you purchase the electoral bond in, say, January, there may not be an election on the anvil at that point of time at all.
My lords,
And you have to expend it within 15 days. Otherwise, it ceases to be valid in the sense that the contributions made to the PM's relief fund.
it has to be cashed within 15 days.
Otherwise,
So therefore, the political party can take it into its accounts. As to when the political party uses the money, there is no limit on that.
That is what Mr. Sibal is arguing, that it can be used for any purpose.
Any purpose at
It
all.
can be used for any purpose. You create a huge political party office. You have residences there for the party leaders. That is sanctioned, and it can be worked at any point of time.
He said that the term electoral bond is a misnomer.
You can purchase an aircraft or a yacht.
Yes. But the point here is my lords, this tranche, each tranche of issue of electoral bonds is normally linked, subject to correction, my lords, so that your lordships can clarify it with the declaration of elections.
It's not available throughout the year. There are specific times.
Specific times. Those times are often matched.
No, the specific months in a year. I think there are four months,
Quarters.
four quarterly.
Quarter.
It also happens, my lords, that almost every quarter there is an election.
No, it's not necessary.
And not
It-
a state or a,
No, it may be a bipole or something, but not every general election doesn't happen.
not a general
Four
election,
times
not
in
a
year.
general election, not a general election. But every few months there is a series of elections, and around that time,
Mr. Sibal is nodding in no, and his experience is greater than yours, at least in that.
that I concede. That I concede. My lords, my respectful point is this: